The Institute.
Institute for Justice.
The National Law Firm for Liberty.
Hello and welcome to Short Circuit, your podcast on the Federal Courts of Appeal. I'm your host, John Ross, of the Institute for Justice's Center for Judicial Engagement. Joining me today is IJ's Senior Vice President and Litigation Director, Dana Berliner, as well as IJ attorney Rob Bicola. Rob is also our special counsel to our Planned Giving program. Rob, what is the Planned Giving program?
Well, broadly speaking, the Planned Giving program is a way that our donors can support us by thinking outside the box. Rather than traditionally peeling off a check, folks can give through including us in their estate plans, opening up a charitable gift annuity with us where we make payments to them for life, or giving to us through their IRA. So it's ways that folks can think creatively and have tax advantages as the cherry on top as a way to contribute to IJ.
Okay, thanks. And with that, let's go into our first case, which comes out of the Fourth Circuit. Dana.
So our first case this week has to do with a law that was passed after the scandal about Russian interference in the elections. Maryland then passed a law that was supposed to address the possibility of foreign interference. But the way that they did it was surprising. The law required that online platforms, which means any website, including news websites, that have more than 100,000 visitors a month, have to now report for every political ad who purchased the ad, anyone who controlled the purchaser, the amount paid for the ad. And then that same website also had to keep a bunch of records about each political ad for at least a year and then provide that information to the government upon request. So this was one of the first laws that was really directed not toward the political speaker, but instead toward the website or source that then published the speech. And that turned out to be important to the court because the court, there's so much case law allowing regulation of people running for office and the disclosures that they have to make, but not really this kind of law that applies to just complete third parties and places a lot of requirements on them. So there were a number of really interesting legal holdings here. First of all, the court affirmed that this was discrimination based on topic. So this was a rule that applied to laws about, to ads about campaigns, but not to ads about anything else. And that's important because although the U.S. Supreme Court has said that discrimination based on topic requires what's called strict scrutiny, which I'm sure any listeners to this podcast or to Deep Dive will understand means that the courts actually care what the government is doing and will look at it closely. Nonetheless, most courts don't seem to understand that discrimination based on topic is something meriting strict scrutiny. And that's an issue that IJ has been trying very hard to get courts to recognize. So it was great that the Fourth Circuit recognized it here. The Fourth Circuit also recognized that having to publish information about ad purchasers is a form of compelled speech. And that, too, is important because in recent decades, courts have not been very interested in compelled speech and don't seem to care very much when regulations require compelled speech in the context of advertising. So they're still only applying it to these third parties and not to the candidates themselves. But the fact that they even care about compelled speech is great. And the other thing that I thought was really useful and important was that the court spoke positively about anonymous speech. And anonymous speech was critical in the founding of our nation. Most of the political debates that were going on pre-founding were all published anonymously. Federalist Papers, anonymous. And yet, with this sort of passion for disclosure that has been going on now, the importance of anonymous speech has been routinely discounted by courts. So I was really happy to see that this court recognized that that was an actual thing to be interested in. And so the court struck down the law. It said that it was not justified. It had far too many effects on speech. It did not achieve its purpose, and it was having a major chilling effect on news websites and other websites. For example, Google has stopped running Maryland political advertisements because it was just so much of a hassle to do all of this reporting. So it struck it down. The lower court struck it down. The Fourth Circuit affirmed the preliminary injunction against it, and we'll see what happens next. But I'm hopeful that this opinion will stay in place, and I think that it will.
You mentioned Google and newspapers. Who are the plaintiffs in this case challenging the law, Rob?
In this case, it was actually the platforms that had to comply with this. So the opinion actually, refreshingly, I think, delved into the sort of bureaucratic red tape that they would have to comply with in order to manage this sort of regulatory scheme. And I think the opinion even had the term "why bother" as a way that to show that when the platforms are faced with either going through this sort of turgid regulatory framework for documenting and maintaining all of this and disclosing all of this information versus just stopping that kind of speech from existing on their platform at all, I thought was refreshing. Dana and I were chatting yesterday about rational basis cases where there's no real deep dive into the actual real world effects that a law and regulation can have. This was sort of the opposite. And it sort of goes to a theme that we deal with, which is that in First Amendment cases, which is a right that courts tend to care about more, there's a sort of probing, searching look at the actual way a burdensome regulation affects the people and the public that are subject to it. So it's definitely a sort of object lesson in what actual judicial review looks like.
And I will say I'd say 5 or 6 years ago, I was very concerned that rational basis kind of deference was creeping into even First Amendment jurisprudence. But that seems to have stopped now. And this decision, as well as others, are a real sign that at least in the First Amendment context, real scrutiny is what's going on. And we're not seeing the spreading of rational basis review into First Amendment anymore, which is good.
On the last episode, we talked about the Americans for Prosperity disclosure case out of the Ninth Circuit. I think we said the exact opposite thing.
Well, that's true. It is the Ninth Circuit. So one major difference also with the Ninth Circuit decision was that involved a regulation of the speaker itself. And that's a major distinction that the court drew here. The speaker, political speaker, can be required to do an awful lot of disclosure. And in that's some wrong decisions that the U.S. Supreme Court has made in the past that we're hoping they'll reconsider at some point. But here it was a regulation not of the political speaker, but of the Washington Post, the New York Times, the Cecil Whig, any large or small news site or online platform, essentially. And the court drew the line at that.
Okay, with that, let's move on to the next case, which comes out of the Fifth Circuit. Dana?
So in this case, Walmart stores versus Texas Alcoholic Beverage Commission, Texas passed a law some time ago that prohibited any publicly traded corporation from owning a liquor sale permit, of the type that you could go to a store, purchase a bottle of something or another and leave. Restaurants and other kinds of businesses could still have liquor permits, but For actual liquor stores, those could only be held by non-publicly traded corporations or by individuals. And Walmart challenged this as a violation of the Interstate Commerce Clause and also the Equal Protection Clause. And below, Walmart actually won under the Interstate Commerce Clause. On appeal, the Fifth Circuit upheld a portion of the opinion, but mostly vacated it and sent it back down to the lower court to reevaluate. And I think in a way that's going to make it difficult, although not totally impossible, for Walmart to win. So what the court said is that a law which appears neutral on its face, as this one does, it doesn't specifically say anything about out-of-state, must be discriminatory against out-of-state interests in either its purpose or effect. And that's pretty standard language. The court below had said it was discriminatory in purpose, but not effect. And the appellate court, the Fifth Circuit, said that the lower court had not properly evaluated purpose. And I found this somewhat difficult, really, to understand. So what it said was that discrimination based on corporate form, meaning publicly traded or not publicly traded, was not the same as discrimination against interstate commerce. Now, mind you, 98% of the stores in Texas are owned by Texas residents. And that's not surprising because this makes it very hard for anybody else, including even an out-of-state resident, to own a Texas store. But despite that 98%, the court said, oh, well, it's hard for the Texas corporations too. So this doesn't necessarily discriminate against out-of-state interests. It just discriminates against corporations. And it then kind of kicked it back to the trial court to say, was there really a discriminatory purpose? And this I found particularly disturbing because the appellate court did not accept evidence that the law was drafted by the current in-state interests and that their reason was to keep Walmart in particular out.
It was the lobbyists for the liquor stores
Yes.
who wrote the law.
Exactly.
And that didn't count.
That didn't count. And it's not clear to me what evidence would count. You can't ask the individual legislators what they were thinking. So I'm not sure what kind of evidence the court wants that the legislative purpose was discrimination against out-of-state. The fact that it was written by the in-state lobbyist seems like that would be pretty good evidence. And yet the appellate court was not convinced. So that was a problem, and I think really creates some tension on the issue of purpose because courts say don't look into the subjective motivations of the legislature. But then here, the court seemed to reject any evidence that wasn't the subjective motivation of the legislature. So I don't know what it's doing. The other thing I thought was interesting is that the decision and the whole line of cases about how discrimination against corporations is not discrimination against interstate commerce is really not quite consistent with the recent decision in Tennessee Wine and Spirits, which was our case. In that case, the U.S. Supreme Court specifically said that the courts should look at whether the predominant effect of a law was protectionism or public health and safety. And here, 98% predominant effect is to shut out-of-state owners of liquor stores. And yet, that's not how earlier cases have treated either purpose or effect. And I think there's going to be a need to really resolve which of these tests apply, because the effects test, which the Fifth Circuit and the lower court both said that this was not discriminatory in effect because it applied equally to Texas corporations, even though, again, 98%. So I think that the way that the courts have evaluated this is not quite consistent with the latest Supreme Court decision. And I'm hopeful that at some point the Supreme Court will resolve that. The Fifth Circuit didn't totally kill the case, so it may live another day. We'll see what happens on remand, but it certainly wasn't a promising decision. And then I should say something about the equal protection claim as well. That is, we actually did a friend of the court brief in this case specifically about the equal protection claim. And the argument there was that it was treating corporations differently than non-corporations or publicly traded corporations differently, and that there was no rational reason to do that. And the appellate court definitely said, yeah, it's completely fine to make this kind of law and it's justified, but at least we got a line that said that rational basis was a fact-intensive review. And that was something that we pushed very hard for and that we push very hard for in all of our cases, is to make courts understand that you can present evidence that a law is irrational. Some courts don't even like to allow that. And I was happy to see the Fifth Circuit say that. But it is also true that they found here that the idea of just making it harder to get liquor was a sufficient justification for this law. And I will say that unlike some of these rational basis decisions where the justifications make absolutely no sense at all, here there was something in that they said, look, if Walmart can sell it, there's going to be more sales of liquor and they'll be cheaper, so people will be able to buy it more. And under the 21st Amendment, states can indeed discourage more purchases of liquor. So it wasn't a totally crazy rationale like courts sometimes come up with. It was still wrong, but it wasn't embarrassing in the way that a lot of rational basis cases can be.
It was encouraging to see that language in the opinion. And I think it also highlights why it's so important that IJ is out there litigating these cases, because I don't think that the advocacy below in this case was necessarily focused on really advancing that rational basis jurisprudence further and fully developing the record the way IJ would. And so it just highlights why it's important for us to be fighting hard on that battle, because often the parties in cases understandably have different priorities.
And there was nice language. It said rational basis review is fact-intensive. It said it can't be fanciful, that the government justifications can't be purely imaginary, which is shouldn't need to be a important statement of a court, but it is. And there aren't that many decisions that remind courts that the reasoning shouldn't be fanciful. So I was happy to see the Fifth Circuit say that.
Okay, and with that, let's move on to the final case, which comes out of Louisiana. Rob.
Well, this was an interesting case that started off with a novelist's almost factual premise, which a suicide note from a Louisiana court administration staff had confessed that during a broad period of time in the 90s and aughts, that there was a policy and practice within the Louisiana state court system of summarily denying habeas petitions from prisoners. In other words, prisoners who were petitioning the court for review of wrongful imprisonment being denied wholesale, but without ever being reviewed by a judge. To make matters worse, for each habeas petition, the court was collecting money from the jurisdiction that case came from and keeping what the parties here were calling a slush fund. This case made it all the way up.
Sorry, what was the money for?
It was so essentially for each of these petitions that came before the court, whatever local jurisdiction that it came from essentially had to pay money to the court system that could then be used by the justices for their own reimbursements, for office expenses. If this all sounds familiar, it's because it's an issue that IJ deals with a lot, which is conflict of interest and profit incentives in our justice system. In fact, the petition here trying to get Supreme Court review cited a number of cases that IJ is really focused on trying to revive. One is called Toomey versus Ohio, where you had a mayor sitting in a judicial function, hearing cases, and also profiting from the fines that came from that. And we have used that line of cases very effectively in our litigation here. In fact, that was part of the sort of doctrinal push that allowed us to shut down Philadelphia's civil forfeiture system, which involved cash going back to the very prosecutors and police who were bringing these cases, thus creating a conflict of interest, as was alleged here. So it's really unfortunate that this case wasn't taken by the court. And indeed, Justice Sotomayor wrote separately, which is not a very common thing when cert is denied, to say almost hopefully that perhaps a case that is properly postured to bring this issue up will come to the court. In this case, because the issue wasn't preserved below, in other words, and this is not surprising given that this was a pro se individual representing themselves from a prison, articulating every possible claim in that proceeding is very hard for these folks. And so I share Justice Sotomayor's hope that someday this very important issue will come up, because there's been essentially a confessed miscarriage of justice in the Louisiana criminal system. And in many important ways, it's evaded meaningful review by the U.S. courts enforcing the U.S. Constitution. So another sort of interesting moving part of this case was, and I want to make sure I get this name right, the Anti-Terrorism and Effective Death Penalty Act of 1996. Like so much legislation passed in the wake of a great tragedy, this had some really unfortunate consequences. This came in the wake of the horrible terrorist attack in Oklahoma City, and seizing on that sort of public outrage and desire to see folks like Timothy McVeigh face a swift execution, this act, in addition to that, had essentially a effect of curbing the ability of prisoners to raise habeas petitions, and really limited the scope of review for courts to review those. In fact, it's called its own category of deference, essentially making it harder for people who claim they were wrongly convicted or suffering a really grave miscarriage of justice from having their day in court. That level of deference would have also been an incredible thing for the court to be able to review. But again, it evaded review here. It was concerning to Justice Sotomayor, and I think it's concerning to anyone who is interested in making sure that everyone has their day in court and has meaningful judicial review of the most important thing in their existence, which is their personal liberty.
I was troubled that it appears they rejected it simply because this person didn't raise the issue perfectly below. I just don't see how a pro se prisoner can be expected to do that and can be expected to understand that there was this financial incentive going on, that there was this practice going on, and exactly what constitutional right that implicates. Because it's not like some pro se person is going to know about Toomey versus Ohio. And I felt like the court could have taken this, and given how insane this approach was and how important it is to say that federal courts are not going to defer to a rubber stamp of a staff member in Louisiana who isn't even a judge, I think they ought to have taken it.
I completely agree, and especially since this is a problem that goes beyond Louisiana. Here at IJ, we've noticed a real trend in courts that don't have actual judicial resources, i.e. judges, taking evidence and making findings of fact and conclusions of law, particularly when it comes to property rights. Oftentimes there are specialty housing courts that are popping up across the country where a person can be cited for various fines related to their property and maybe even end up losing their home, all without meaningful review or review at all by a judge. So this is a real problem and sort of goes to the fundamentals of our justice system. And it points out, as Dana mentioned, a real flaw, which is that we expect people who are not only legally untutored, but incarcerated to make a pristine record preserving each intricate legal issue for an appellate court's review. I just don't think that's realistic, and probably it's unfair.
Okay, that concludes the show. We'll be back in 2020 with more judicial engagement. Until then, this is John Ross from the Institute for Justice, beseeching you to get engaged.